Welcome back. Yes, indeed. We're talking Kano politics. And as you've seen there, Mr. Abdulkadir Sani joins us now. He is the National Vice President North for Nigerian Law Society. Good morning, and thank you for joining us today on the program.
Good morning.
Okay, so let you listen to this. This is coming from the Public Relations Officer of the of the Kano State Police Command. So listen to this.
The position of the law is very clear. Section 4 of the Police Act 2020 as amended provides the responsibility of the Nigeria Police Force, which is protection of life and property. And of course, you are very much aware of the court order received by the police command here in Kano. Item 9 of the order provided that the police should not participate in the coming local government election in the state. The police in Kano are not participating in the election. But however, it is our responsibility to ensure no breakdown of law and order in the state, and we are always alive to our responsibilities. The State Commissioner of Police, CP Salman Dogo Garba, has already directed all the command's operational commanders to ensure protection of life and property in Kano State. And he directed for continuous round-the-clock visibility patrols to ensure that the inhabitants of the state are safe. Thank you.
Okay, so Mr. Sani, some interesting scenario there. Now, the background to this is that, there had been a court judgment, they say in the first instance, from the Kano High Court that no one should stop the election from going on. And then another group said they went to court and equally got a judgment which says you cannot proceed with the election. They dissolved KANSEC and suspended the chairman of that commission, saying he was a card-carrying member of NNPP. And now they say there's going to be another judgment delivered today, this morning, and they are waiting to see what will happen. But in the meantime, preparations are in top gear for the forthcoming local government elections. So with the police saying they will not participate, give us your perspective. What is the position of the law on this matter?
Well, you said we have judgment of two courts. One supporting that no one should stop the election. And the second one is saying that the KANSEC is disbanded not to participate in the election. Not to even conduct. Not only that, it nullifies every step that has been taken so far. Now, the position of the law is clear. If you look at the first judgment, the first order which was given by the Kano State High Court, you realize that the parties are not entirely the same with those that of the judgment given by the Federal High Court. KANSEC went against political parties, requesting the court to stop anyone who intends to conduct himself in a manner that will prevent conduct of the elections. If you ask me personally, I will tell you that is preemptive. Now, for the matter which was before the Federal High Court, the matter was litigated fully and judgment was entered. One of the grounds of the judgment is that, like you rightly said, people who constitute the KANSEC are card-carrying members of the NNPP. You see, when you have a judgment, the position of the law is this. An order made by a court of law, no matter how bad, subsists until it is set aside on appeal. And then I do not understand if at all there is any order by the first court why the political party did not go against that particular order, either by asking the court to vacate the order or set it aside. That being what that is, that the one before the Federal High Court was very explicit. Court gave judgment. Even if you have reservation for that judgment, we live in a system that is guided by rules and regulations, and in fact, provision of the Constitution. If the Federal High Court has pronounced on that, I believe that the right thing to be done is for you to contest this on appeal. Because by the time you begin to have conflicting orders, if at all the two amount of conflicting orders, we are inviting anarchy. You have just had the spokesperson of the police saying they are not participating. Kano, by its nature, is one that we must be careful when we have situations like this. You do not have election, you have serious crisis that led to burning down the High Court, the main complex of the Kano State High Court. Now, you're having an election and you are saying that the police are not participating. Of course, by order of court, they must obey the order of court. So if they are not participating, you can just imagine the scenario that you're going to have.
So a number of things pop up there. Pardon me to jump in.
Very strong
now,
contenders, political party. I don't know. I don't want to imagine that the crisis will, that will be imagined from that scenario.
So a couple of things come up here. I hope you can hear me though. Now today, there was supposed to be that judgment delivered yesterday, but the judge was not available. And so they moved it to today. So I think they seem to be optimistic that the judgment will favor the conduct of the elections. Now, if and when that judgment comes in today, assuming that it does say, go ahead and conduct elections, it means that, that will be the subsisting judgment that they'll have to adhere to, isn't it?
That's correct. But you see, if you look at it, there is a judgment subsisting already. Are you telling me that the same court will set aside the judgment of a coordinate court? It is not done. That's not the procedure. So no court of coordinate jurisdiction has the power to set aside the judgment of his learned brother.
That's the interesting thing about this.
The only court that can do that with jurisdiction is the Court of Appeal.
Some of those who argue about this, they say that now, when this second judgment came, they are arguing that this court had no jurisdiction. And so they don't think that this is a valid judgment, and so it's faulty by itself. And now, if this one comes through, another group will have a problem with this one.
Okay, you see, it does not lie in the mouth of any contender or any participant to say that judgment is not valid. The exclusive power to say the judgment is not valid is in Court of Appeal. So you cannot determine what judgment is valid, which is not valid. That is why I said there is presumption of regularity, presumption of correctness in any judgment delivered. This is why, you see, at this point, I think the judiciary must step up. It is high time we start having conflicting judgments. The law defines the jurisdiction of each of the courts. So if anyone overlaps in his jurisdiction, it is either there is no clear understanding of the law or it is done with malice, with all due respect. So the disciplinary mechanism must be put in place to stop this. We can't push ourselves into anarchy, for God's sake.
So there's a role for NJC here.
Yes. There is the role of NJC, of course. You see, you do not have a court pronouncing wrongly without also having lawyers who put in the terrain for the court to pronounce wrongly. The law is clear. Even though it is brought to you, you can look at it and say, look, I lack jurisdiction on this matter. Or you even invite him, address me on whether I have jurisdiction or not. You can't just go slavishly and begin to pronounce on what is outside your jurisdiction. Judges do this as a matter of, guiding themselves, guide them with the law why they have jurisdiction. But to say two courts, one for state high court, one federal high court, pronouncing on almost the same subject matter differently, I'm sorry to say we are heading to an unpalatable destination because society is watching everything. The more you begin to disobey one order and choose which one to believe, you are also telling Nigerians or the populace to choose what order to believe and which not to believe. We must live in a coordinated society guided by rules of law. That's my point.
Do you think that that's what the police have done by saying they're staying away? Or do you think that they're saying we recognize one judgment over the other?
Certainly not. The police, being an agency of the federal government, has obligation to obey, court judgment. They have obligation to obey, laws and order. The court made it clearly for them to stay away. And they said they are not participating. They are simply obeying the rules made by the court. So they are not, you can't fault the police. They have done the right thing. Because if, for instance, they decide to participate after expressly the court has voided every procedure, they are simply saying that they are also in contempt of court, disobeying the judgment of the Federal High Court. With all due respect, this is my position.
While all of this battle, because this we've seen in the wake of local government elections that have now been conducted in different parts of the country following the Supreme Court judgment, what we have seen have been that, a lot of them, the conduct has left a lot to be desired. And as usual, we have seen that, the results always reflect the governor's party. The party of the governor in power in the state. Usually you see one uniform result. And sometimes you do see spirited efforts by members of the opposition to resist what is happening there. Do you think that the outcome of the polls, should they go ahead, do you think that in spite of all of these efforts we're seeing, the outcomes might be different?
Well, let me start with the pronouncement of the Supreme Court. The pronouncement of the Supreme Court is distinguishable from what is at hand. The Supreme Court pronounced that all local government elections must be held, and then there should not be, what is known as usual as caretaker, whatever, which is saying that it illegalize the caretaker and then have the elected officers to come into local government. That is understandable. But it's not to the effect that when there are no compliance with the laid down laws, that the court should not void it. And that's what the Federal High Court has done. It has voided. If, for instance, you have a card-carrying member and other people who are constant of the council being part of NNPP as alleged, how do you believe in the transparency of the election? So I think from what is going on, the result may not be different. It will not, because if the court has voided, including nomination, issuance of form and everything from the beginning, void everything and even sack key officers of the council, and now you are still proceeding, I think this is illegality upon illegality. I've said it earlier, you cannot challenge a court pronouncement unless, of course, you proceed before the Court of Appeal to set that particular judgment aside. So when it is set aside, now you have a clean slate. But whatever they will do now, I am telling you, it is like trending on illegality because the pronouncement is clear. And like I said, this thing still falls back to NJC. This thing must be reviewed. We must have a clear angle where we can say that judgment of the court are no longer conflicting. Jurisdiction are parallel. It shouldn't be.
Ayo.
Well, one of the issue that you have raised now, sir, is one of those that over and over again we've heard this, we've seen this, particularly when it comes to politics. Conflicting judgments, one person saying something, another person, one court saying something about the case, and another one saying something totally different. In fact, there was a case that we heard that somebody in analyzing, just as you're doing right now, was saying that there is no way a court would know what another court have decided on the same issue. And the argument that I put forward to the man was, look, how is that possible when there are lawyers on both sides of the same case who would approach one court and approach another court, and both of them know exactly what the issues are, but the judge may not know? How do you see that really happening? Do you think it is something valid, or is something that legal practitioners just do among themselves? Can you hear me, sir?
I can hear you. I don't know if you can hear me. I can hear you.
I can hear you, but can you hear me now? Okay, well, if you can hear me, let me repeat that question. It's that concern that you raised earlier, the other time when you were talking about the fact that we can't be having conflicting cases of two two decisions or two rulings of a court, of two different courts, about one particular issue and both of them conflicting. It's a matter that's been on for a while. Where do you think the root is? Why does it happen? Why does it seem to happen mostly when it comes to political cases?
Okay, what I think is happening is there appears to be infiltration of politicians into judicial activities, and then it's a very dangerous development. That's why I spoke about jurisdiction of all the courts. If the courts are properly guided by what is laid down for them in terms of jurisdiction, it is clear in the Constitution. I think no matter by what means the politicians are approaching the bench should refrain from attending to their requests.
It's interesting that you
there's no
lay on the
why
bench.
you will have,
if you can hear me, Mr. Sonny.
A clear definition of the law.
Just a second, if you can hear me. Because there are legal practitioners who are also politicians. If you can hear me, Mr. Sonny. There are legal practitioners who are also politicians. The same way we have medical doctors in politics, we have lawyers in politics, we have engineers in politics. There are legal practitioners such as yourself who are also in politics. So where does the infiltration come? Is it that the profession, the practice, is unable to monitor or control itself? Okay. Well, I guess we'll have to come to this again, well, Mr. Sonny, because the issue that is on the burner right now, when you say that the politicians, there's been an infiltration of politicians in politics, of lawyers, of legal practitioners in politics. There are legal practitioners in politics. There are lawyers in politics. There are aviators in politics. There are accountants in politics. So is it that the profession cannot insulate itself? Because it's the same lawyers that go to this court, that go to another court, and both of them argue maybe the same case. So what exactly do you think is the problem? Are there corruption tendencies, or is it that the judiciary is so porous that it cannot defend itself or protect itself from all of these disturbances?
Okay, you see, my take on this is, first of all, there are factors involved. One of them is we must be mindful of the kind of people we elevate to the bench. I read an article sometimes which says the bench is not for failed practitioners. We must appoint people who have clear understanding of the provisions of the law, and the people with vast experience, people who are in practice, who have seen both sides of everything. And then the second one is that there are also interests involved. Of course, like you said, in politics, there are lawyers, there are accountants, there are all manners of professions, who are also involved in politics. But the fact that the interest involved, they are affiliated to a particular political party, what they advocate simply is the interest of that political party. And most often than not, they will be searching for a soft angle where they can approach a judge that will give an order in their favor. And I think this is what is affecting the society. It's not about whether because a lawyer, no, lawyers argue some of this application. But you see, when you bring an application ex parte before a court, it's an application that will be heard without listening to the other side. But it is not out of place for the judge to tell them, put the other side on notice and address me on jurisdiction. So if they come up with the laws, what we call judicial precedent, a judge will safely follow a judicial precedent without liability. Because even if you petition against that judge, the court will still, the NJC will look at the record, look at the argument that we're taking, and see if there are supporting evidence for that judge to act in that manner. So these are the issues. It's mainly interest that each of the professionals advocate at that time. If, for instance, a political party briefs a lawyer and he goes before another court, he is going to argue in favor of that particular judge, a particular party. So that is exactly what is taking us to this destination, which is not palatable.
So, and I'm glad that you mentioned, I'm glad that you mentioned NJC. Just a second, Mr. Sonny.
Section 1, subsection 3.
Yes,
even if by commission or commission,
Mr. Sonny, just 1 second, I hear you. But I'm glad that you mentioned NJC. Just 1 second, Mr. Sonny, if you can hear me. I'm glad that you mentioned NJC. And one of the questions that comes to anyone naturally would be, what exactly is it that the NJC or other pillars in the profession what can they do Shouldn't they also be able to do so? Because you are a legal practitioner. I'm sure several other legal practitioners such as yourself are complaining. There is the body of benches, the SANs, I believe they also have their own body. There is the NJC, there is the Supreme Court, there is the NBA, and it's all of its instruments and infrastructure. Is it that they are powerless? Our judiciary is 25 years old, and this issue that you have talked about is almost, if not even older, and our democracy?
Well, they are not powerless. They are not powerless. I think what is missing from there is that the fact that some of the hearing judges are not sanctioned. But the power is defined, they have the power, but if they don't get sanctioned, that is why you see we keep having this repeat episode of what is happening. But I can tell you the rules that guides the NJC on any hearing judge is still subsisting where you are found wanting. Once you are sanctioned, a lot of people would, a lot of other judges or other lawyers who are involved will get deterred and they won't go into that. Like I told you earlier, if anyone brings application before you and you have mixed feeling about whether I tell him to address you on jurisdiction. Once he addresses you and he cannot show that you have jurisdiction, you decline. You recuse yourself and tell him, I do not have jurisdiction, go to the court that has jurisdiction. But you see, once they come, and then if laden with interest, people just proceed slavishly, and we continue to have two coordinate courts, litigating over the same matter and coming up to a different ending, favoring whichever side that comes before it. The NJC must step up to do the right thing. We cannot continue to have the society in this manner. In Kano, we are particularly afraid of this because the flashpoint is now when there is a crisis about to happen in polling unit, there are no police. There are no law enforcement agents to intervene on this issue. We don't pray it escalate into something else. That's why I said technically we are inviting anarchy. Law and order must be seen to prevail. We must obey court orders at all costs, no matter what. Go to Court of Appeal, challenge it, and then put things right.
Yes, I know you said they should go to Court of Appeal, but does the Federal High Court have jurisdiction over Kano State or over local government matters?
Well, if you ask, because I don't know what argument. You see, there is a subsisting judgment now.
Yeah.
My perception personally, being a local government election, I think the jurisdiction does not lie with Federal High Court. This is my humble, understanding of the law. I think it does not lie, but I don't know what argument was canvassed. I've not seen the record of proceedings, and I have not gone through, I've seen the order, but I've not gone through the proceedings. But the bottom line is, I do not think the Federal High Court has that jurisdiction. A pre-election matter that involves, national election, yes, the Federal High Court has exclusive jurisdiction over that. But I don't think, subject to whatever that may come up, to correct me on that notion, because it's an ocean of learning. But I personally don't think Federal High Court does. Thank you.
Okay, so one more thing. Now, preparations are in place for the election, despite that decision by the courts. Yes, you said the right thing is to challenge it, but at the moment, the elections have not been conducted. Can they be said to have disobeyed the court order?
Absolutely. Absolutely. Whoever is advising the government to proceed in spite of the judgment, whoever is giving whatever courage to the government or to whoever that is involved, including the council, I can tell you they are in contempt and they are proceeding illegally. So whatever they have done, because if you look at the finding of the court, it has nullified everything from the beginning to the end. So whatever you are doing, you are just going on voyage of discovery, which will end up in, absolutely, illegality. So this is my take. As far as the judgment still stands, it's an illegality.
Okay. So until much later this morning, I think they should be sitting by now. So we'll wait and see what happens. Will it hold or not? Time will
tell. Thank you very much. Absolutely. Well,
Thank you.
Thank you.
Thank you for your time this morning.
It's my pleasure. Thank you very much.